I want to continue our discussion about trade secrets here in this presentation. In doing so, I want you to think about a situation where you are accusing others of misappropriating your trade secrets. In this circumstance, you can bet that the accused are going to defend themselves with some or all of the following kinds of arguments. First, they're going to say that the information they allegedly mishandled was not a trade secret at the time they did whatever you're accusing them of doing. They will attempt to show that others in the industry already knew the information when you claim they acted wrongfully. They will add that you didn't protect the information with reasonable security measures anyway, and so it doesn't qualify as a trade secret. Remember the incident where the Apple employee mistakenly left the Apple iPhone 4 prototype at the bar. One of the potential arguments in that event was that Apple did not use reasonable security measures by allowing an employee to so simply take the precious item to a bar where he might consume alcohol. Another avenue that the defendants might take is to argue that they didn't know that the information was one of your precious trade secrets. Maybe they developed the information and so believed that they had rights to do what they wanted with it. They also might say they didn't know what they were permitted to do with the alleged trade secret. That is, they didn't clearly understand what their specific obligations were with regard to the disputed information. So you can't call them bad dogs because they didn't clearly understand how or when they could or could not use the information or tell others about it. As a manager in a company that has trade secrets, you have to think ahead and conduct your operations in a way that will make these arguments look so ridiculous that any rational person, whether a judge or someone on a jury, will readily dismiss them. So, for instance, if they were to argue that they didn't misappropriate your trade secret, you want to be able to easily say, "Oh, come on, Judge. Look at all these facts and circumstances. I put a ton of security into this information, and there is no way that these guys didn't know that what they were doing was wrong." So, you need to anticipate the possibility of trade secret misappropriation and conduct your operations so as to cut any arguments off at the knees. At the end of the day, you want to make it very clear that the alleged misappropriators recognize what the trade secrets were, that you protected the information reasonably, that the defendants knew their obligations, and they willfully misused your trust. They are just bad, bad dogs. My goal here today is to give you a feel for some of the steps you can take to make sure you are on the winning side of a trade secret argument by making the accused look ridiculous with typical defenses. And to do this, I want to focus our attention first on reasonable security measures, because that is often the crux of the inquiry. To begin, I'd like to frame security in light of some overriding considerations. So I want you to recognize the dynamic nature of the whole enterprise. For instance, information that was secret and valuable 5 years ago may now be public or not worth so much anymore. Thus, you may not want to invest as much as you once did to protect it. Also, your firm is constantly acquiring and developing new ideas. Therefore, you have to continually consider if they should be protected as trade secrets, how much they are worth, and what steps are appropriate to secure them. For these reasons, effective managers in technology companies should establish programs in which they periodically review the status of old information, appraise the value of new material, and determine the appropriate mix of security measures that is appropriate to protect them. We call these trade secret audits in the field. Okay, I have told you that it's a good idea to engage in periodic trade secret audits. So now you have to figure out who would be best to do this work. I can't really give you a hard and fast rule on that, but I would recommend a team of individuals. For one, you probably need an engineer or a tech-savvy person who can look at particular pieces of information and say, yeah, that's still a trade secret in the field and it's important. Or, no, that's not state of the art anymore, or it's widely known now. Along with the engineer, I might want a security expert who can help determine what kinds of measures would be appropriate to protect the different forms of trade secrets that your engineer helped identify. I might also include an IP attorney, because lawyers understand trade secret laws and what measures have led to good negotiating and litigation outcomes. Finally, you will probably want an operations manager on the audit team who will be responsible for implementing the desired measures. All right, so you have this audit team, and their job is to identify the trade secrets, recognize their value, and determine the kinds of security measures that make sense. So, one overall important general consideration that I want to mention is that you should try to only allow individuals who have a need to know the secrets to be able to gain access to them. Not surprisingly, we call this need to know access. Another thing is that at the end of the day, you want to have an appropriate combination of security measures that makes sense under the circumstances. And the notion of what is reasonable depends a lot on applying a cost-benefit analysis. Thus, the benefit you seek is that you will maintain the value of your information by preserving its secrecy. The question then is, what set of measures are worth it, given their implementation costs and potential effectiveness? And that will depend a lot on who has to handle the secrets, where they might have to use them, whether the information is stored digitally, and a host of other considerations. On this next slide, I have begun a list of protection steps that you might want to consider when developing a plan to protect information. You don't have to choose them all. Rather, you need to select an appropriate combination that you can defend in light of a cost-benefit analysis. Having said that, I put confidentiality agreements first, and I highlighted it in red because when disputes arise, the first thing that judges will expect to see is that the company had its employees and other relevant individuals sign confidentiality agreements. Confidentiality agreements are your way of directly telling someone that they will be encountering trade secrets, what those trade secrets are, and what their duties and obligations are regarding the secrets. As for identifying the relevant information, the agreement usually provides only a general statement about the kinds of information that typically include trade secrets. And the company then will rely on other measures to specifically finger what they are. Just to give you a flavor, here is a portion of how Chevron defined confidential information in its employment agreement. So it says, the company's confidential information includes, there's a lot here, information embodied in inventions, discoveries, and improvements, whether patentable or unpatentable, geological and geophysical data and analyses, well information, discoveries, development initiatives, reserves, offshore bidding strategies, exploration and investment plans, business methods, current and planned technology, blah, blah, blah. Human resources data, customer lists, pricing, supplier lists, any other information having present or potential commercial value, and confidential information of any kind in possession of the company, whether developed for or by the company, including information developed by me. So, in addition, the agreement makes it clear that confidential information does not include information that is generally known outside the company. So we're not talking about all information, only the information that is secret. The agreement further instructs that confidential information shall not be limited to information marked with words such as classified or restricted. Thus, just because some material may have a legend, which is one of the security measures that you should consider, this doesn't mean that unmarked documents are necessarily fair game. The statement that confidential information can cover work developed by the employee can be particularly important when employees leave the company. We've already addressed how employees assign inventions through their employment contracts and the limitations that may exist in certain states, such as California. Most contracts, including this one from Chevron, require employees to also assign copyrightable materials, trade secrets, and trademarks while working for the company, even if developed at home. Chevron's agreement even includes ideas and concepts within the assignment clause. So, again, I can't emphasize enough that when you take a job with a tech company, actually any company, you really should read your employment contract very carefully. I had you read ICM versus digital transactions to give you a taste of how disputes can arise when talented employees with many pre-existing skills leave a company and work somewhere else, or, as in that case, form their own competing firm. Much of the dispute centered around asking, where does the programmer's personal knowledge end and the company's trade secrets begin? The employer won this case thanks in part to the confidentiality agreement, which definitely bolstered its position and helped convince the judge. All right, so besides identifying the trade secrets, the confidentiality agreement also provides what obligations the employee has regarding the protected information. Chevron's contract again uses language that is pretty typical. It says, I agree at all times during the term of my employment and at all times thereafter to hold in strictest confidence and not to use, except for the benefit of the company, any of the company's confidential information, or disclose to any person any of the company's confidential information, except if expressly authorized by the company's management. So, you can see here that Chevron makes it very clear that the employees have a fiduciary duty to handle the information appropriately. They can only use it to further Chevron's business, and they cannot disclose it to others without permission. Okay, there are a few other relevant clauses that you may find in confidentiality agreements that I would like to point out to you. In the Chevron contract, one provision is headed as former employer information. And it says, I agree that I will not improperly use or disclose any confidential or proprietary information of any former or concurrent employer, and that I will not bring onto the premises of the company any unpublished document or proprietary information belonging to any such employer. So I want you to think what Chevron is trying to accomplish by having the employee swear to this. As always, the bottom line is about who we might consider to be a bad dog. So think of this. Chevron hires a new employee who previously worked at Exxon, and he helps to design improved drilling equipment. Exxon gets suspicious and sues the employee and Chevron for trade secret misappropriation. So let's say the employee did it. He learned some valuable proprietary techniques at Exxon and used them to develop Chevron's new technology in violation of his obligations to Exxon. So he's a bad dog who engaged in trade secret misappropriation. Thus, Exxon will win the suit against him, but honestly, he's not going to have enough money to compensate Exxon for its losses. Now, what do you think? Did Chevron engage in misappropriation? The management is going to argue, how are we supposed to know? We told him not to, and he promised us that he wouldn't. We are as shocked as you are. We had no idea. And of course, we're probably going to fire him because he's the bad dog, certainly not us. Okay, I want you to think back to the last bullet on the slide about what bad dogs do. Chevron used trade secrets that came from someone who broke a duty to maintain secrecy. That's the new employee. But they are arguing that they didn't know or reasonably should have known of the breach under these circumstances. Now, if you were the judge, what would you rule? Maybe you'll determine that Chevron should not pay for the harms that have resulted to date, but prevent the company from further use because now it knows. Just remember, it's all about fairness. And so this is the kind of solutions that judges will seek. There are also a couple of provisions that apply when the employee decides to leave Chevron. One is kind of the flip side of the previous matter. The provision has the heading notification to new employer. And it says, in the event that I leave the employ of the company, I hereby grant consent to notification by the company to my new employer about my rights and obligations under this agreement. So basically, this means that if an employee leaves Chevron to take a job at, let's say Unical, she has given Chevron managers permission to inform Unical about the kinds of projects that she worked on at Chevron and that she has duties not to use and disclose trade secrets related to those tasks. This puts Unical on notice that it should be wary if this employee works with similar matters for it. If there ever is a dispute, Chevron will then argue that Unical at least should have known that the employee might be using its trade secrets due to the advanced warning. The other clause I will mention is about returning company documents. And in the Chevron agreement, it says, I agree that at the time of leaving the employ of the company, I will deliver to the company and not keep in my possession, recreate, or deliver to anyone else any and all devices, records, data, notes, reports, emails, drawings, blueprints, this, that, and the other, developed by me pursuant to my employment with the company or otherwise belonging to the company. Basically, this says that the employee will return just about anything he or she has touched at the company and not bring it with them to assist in their next job. It's like, don't let us even catch you with a USB drive or whatever after you leave, or you will be in so much trouble. Now I want to address the other measures that you should consider adopting to protect your trade secrets. I want you to think about these from a couple of perspectives. One goal is to make it clear to your employees what information you consider to be confidential and valuable. Another is to ensure that if someone misappropriates your secrets, then you can demonstrate in court that you protected them with reasonable security measures. But perhaps the most important reason is to prevent the secrets from getting out in the first place. Really, once the secrets are out, they're out. And the responsible party may not have enough money to compensate you for your loss. Thus, the best protection is to prevent the bad dogs from gaining access to your information. So, I'll just rattle some of these off. Restricted access means that you should establish barriers to confirm that only appropriate individuals will be able to see or handle confidential materials. These can be physical locks, card entry keys, passwords, techniques that make sense under the circumstances. Also, you may be able to divide the information into reasonable components so that most individuals can only see the portions that they need for their work without accessing the secret sauce in its entirety. You may also want to label confidential material with a legend, confirming its secret status and perhaps the level of its importance. It's like, I've told you that you will encounter confidential materials in this job, and boom! This is definitely one of those items you need to treat carefully. And if you end up suing someone for misappropriating that information, it may sound more ridiculous if they say, "How was I supposed to know that this was confidential?" Having said that, I want to discourage you from taking the legend strategy too far. For instance, you might be tempted to simply mark everything as top secret so that nothing slips through the cracks. However, if you do this, then the statement may lose its informative value. What would you think if you encountered information that you recognized as pretty public, but it was marked as top secret? Once might be okay, but if this happens on a regular basis, then you might start to believe that you can't trust the legend because it's just so frequently wrong. Thus, it's important to take care and only mark the truly confidential materials with an appropriate legend. This, by the way, is just another reason to engage in periodic audits, since they give you the heads up to remove legends from items that no longer contain secrets. Okay, I don't really need to talk about internet and computer security. You understand the importance of these measures and already deal with them on a regular basis. The methods you use are obviously dependent on a variety of factors, such as possible hacking techniques and the inconvenience of effective countermeasures. Exit interviews is where you collect all the stuff that may contain or allow access to confidential information before an employee departs. Get the computers, USB drives, card entry keys, etc., etc. Also, you want to remind departing employees about their continuing obligations to maintain the confidentiality of your trade secrets. Remember, you can't use it or disclose it. The next item is a warning that you not only need to focus on your technical personnel, but your marketing employees as well. They typically will go to great lengths to make a sale, so you may need to remind them not to disclose too much in their attempts to close a deal. Also, pay attention to their sales brochures, trade show materials, and any other promotional activities. I put external parties on here because Whenever you disclose confidential information to folks outside the firm, then you will need to deal with them in much the same way as your own employees. So they will need to sign confidentiality agreements and promise to protect your secrets with an appropriate combination of physical and technical security measures. We're going to talk about shrink wrap and click wrap licenses very soon when we go over the trade secret litigation involving DCSS, which was software that allowed users to easily rip videos to their computers. I really just put it on here for completeness, but in a nutshell, these are ways to get customers of publicly sold products to make confidentiality commitments prior to opening the merchandise. I put the final trade secret protection strategy, the use of non-compete clauses, in red because I hope to focus more attention on it during the live class session. These are provisions in the employment contract where employees agree that if they leave the company, they won't work for a competing firm for a specified amount of time. Well, you can imagine why these clauses are so controversial because they can severely restrict the ability of employees to seek new jobs in their field. They've become such a hot potato, in fact, that several states, such as California, prohibit them. And others limit their use to higher paid employees who are the most likely to have access to substantial trade secrets. Okay, the last topic I want to address in this presentation is how a company catches a bad dog. That is, how do you prove that someone misappropriated your trade secrets? For instance, you have an employee who leaves your company and goes to work for someone else or starts his own business. And very soon thereafter, they are making products that are suspiciously similar to yours. And you're thinking, you obviously used my trade secrets because there is no way you could have come up with it that fast on your own without them. Evidence like this is often all you've got, and it can sometimes be enough. We call it circumstantial evidence because you don't have direct evidence, such as somebody directly stating that they used or disclosed the secrets. Rather, you are reaching the conclusion because it seems improbable that the resulting circumstances could have transpired without misappropriation. The first three elements on the PowerPoint slide are the kinds of circumstantial evidence that often make the case. I spent a lot of time and money developing the information, and then another company somehow does it quickly. How did they do that? Oh yeah, somebody at that company visited my facilities. Or, oh yeah, one of my employees joined that other company. Or, oh yeah, they gained access to my information in some other way that I can prove. This kind of puts the shoe on the other foot and puts heavy suspicion on them, and is often enough to convince a judge or a jury of their guilt, unless they can come up with some other believable explanation, such as, oh, we can prove that we were working on it long before the employee joined our firm, and we just happened to complete our trials when he arrived. So, in the ICM versus digital transaction case, Newland and Vafa spent years designing software modules at ICM, and then they left to form DTI, and within weeks they have very similar competing programs. That was enough circumstantial evidence for the judge in that case. There's a Supreme Court case where a company worked 17 years to develop some useful purified crystal. A few of the scientists then leave. They form their own company, and within a year, it's doing the same thing. It's like busted. And have you seen the Facebook movie? called The Social Network. Has great acting, by the way, by Jesse Eisenberg as Zuckerberg. And Justin Timberlake is in it also. Anyway, there are twin brothers. They're Olympic rowers. The Winklevoss brothers. And they conceive of a business that they first called the Harvard Connection. It's a social media dating site for Harvard students. They brought in Mark Zuckerberg to design the software. He stalled, and in the meantime launched the Facebook, which was conceptually similar. And the rest is history. The Winklevoss twins allege that Zuckerberg misappropriated their idea and that he's a bad dog. They sued him for like zillions, but they end up settling for about $65 million. One of the problems in their case was the lack of certainty about Zuckerberg's employment relationship and the fiduciary responsibilities that he owed to them. There was no formal employment contract, confidentiality agreement, and no definitive security measures. So Zuckerberg might not have known what elements were trade secrets or that he was supposed to keep them in confidence. He might say, hey, I just helped them for a while with some programming stuff and then did my own thing. I never promised I would not do something similar. We never even talked about it, so how should I have known? So I bet the Winklevosses wish that they had taken this class before working with Zuckerberg, because then they would have made him sign a confidentiality agreement, identifying the secrets and explaining his obligations. But they were just Harvard students, so you can't really blame them. But without it, it was harder to prove that Zuckerberg or his company was such a bad dog. And so they settled. I will end this by letting you know that on some occasions, the aggrieved company will have direct evidence of misappropriation. Or, as I say here, the bad dog is caught red-pawed. For instance, there was a case where these employees left a software company called Cadence, and they created their own competing firm, which they named Avant. Now, Cadence had trade secrets in software programs that took a lot of time and money to develop. The company protected these secrets with reasonable security measures, and all of these ex-employees had signed confidentiality agreements. Anyway, the employees left and then very quickly created software that was very similar to the programs at Cadence. So there is high investment, access by alleged bad dogs, and rapid development. But on top of that, Avant's software contained coding bugs. And exactly the same mistakes appeared in Cadence's products. You know, it's just impossible for that to happen by chance. In effect, they were caught with the goods. Case closed. I'll give you one more example from the hotel industry, which is surprisingly competitive on a lot of different dimensions. Starwood, a major player in the industry, went through secret development of a new kind of very hip hotel, which they ultimately called W. But while in the preliminary design stage, they referred to the project by the code phrase, Den of Zen. In this phase, they worked on different kinds of room layouts, kitchens, bar scenes, marketing approaches, and other aspects that contributed to the overall ambiance that they wanted. A couple of Starwood executives left the company and joined Hilton, which then quickly came up with its own chic hotel line that it very suspiciously called Denizen. I'm not kidding you. So, all of that is bad enough in and of itself. I actually imagine it might have been enough circumstantial evidence by itself for Starwood to have won. But it was worse than this, because Hilton was facing other lawsuits brought by Starwood, and in one of those, Hilton's attorney noticed that Hilton had a box of documents regarding plans for the Den of Zen that belonged to Starwood. The lawyers, in a show of ethical behavior, determined that they had to inform Starwood about the documents. And so Hilton was effectively caught red-handed with confidential secrets in its possession. And, of course, Hilton lost the case and its feeling of zen. Now, I don't wish that same fate upon you. I want you to stay calm and spiritually content. So, to that end, I'm going to now say goodbye. We will look at remedies and the DCSS decision next, probably in class. Until then, stay zenful, my friends.